Sexual harassment is a form of sexual discrimination, okay? Someone who has been discriminated against based on their gender in the workplace, either they were demoted, assigned to an undesirable position, passed over, or sometimes even fired, and the motivating force or factor behind that is gender, that is sexual discrimination. Sexual harassment is a variation of that. If a person in the workplace is subjected to unwelcome sexual comments, remarks, or innuendos, which have the purpose or effect of substantially interfering with their employment, that is sexual harassment. When the sexual harasser, the person who is perpetrating the sexual harassment, is not an employee of the company in which the person works, this is called third-party harassment. Okay? And the only way to hold the employer liable is if the employee complains about the third party's harassment. Say, for example, in a sales setting where you've got a customer that is sexually harassing one of the representatives, the representative brings that to the attention of the employer, and the employer does nothing about it. That doing nothing is a ratification, an endorsement of the sexual harassment, and that gives rise to a claim against the employer. Where we see third-party harassment or ratification, sexual harassment, is in the restaurant and bar context. For example, you have a waitress who is serving a customer, and say that customer comes in all the time and constantly comes at that person with sexual remarks, sexual innuendos, maybe even physical touching, and the waitress brings those complaints to her boss, and the boss does nothing about it, and she's continuing to have to serve this person. That can give rise to a claim against her employer, the bar or the restaurant, for endorsing and ratifying the customer's behavior. One of the biggest fears that people have in bringing a sexual harassment complaint is that they'll be ostracized from whatever the working community is. In the restaurant business, we all know that there are local markets, and bartenders, waiters, and kitchen staff can move restaurant to restaurant. So a person who makes a sexual harassment complaint may feel that they'll never get a job within the industry, which is a legitimate fear and results in them never reporting things that happen in the workplace. But the protection that they have is actually in the reporting, because if they report it and they are terminated, not only can they sue the employer for sexual harassment, but they can also bring a retaliation claim against them because of the fact that they reported it and their employer retaliated against the reporting, as opposed to doing the right thing, right? And the right thing would be to address the harassment and eradicate it, to stop it, so the person can work in a sexual harassment or an environment that is conducive to just professionalism and not the nonsense that we see sometimes from folks that maybe they're drinking, maybe they're just being belligerent, or they're just being overly sexually suggestive in an inappropriate way. Anytime a person is facing sexual harassment or discrimination of any kind in the workplace, they must report it, and they must report it through the channels that the employer has in place. If you fail to do that, you will not be able to later bring a case against the employer, because there has to be some fault. And there is not going to be fault on the employer until they're made aware of the problem. Once they're made aware of the problem, the employer has an obligation to A, investigate it, and B, take prompt remedial measures to stop it. So you need to give them the opportunity to do that, and if they fail to do that, then you can bring a claim against the employer for either sexual harassment or some type of employment discrimination. Someone can quit from sexual harassment or because of sexual harassment. However, they have to first report it. They have to give their employer an opportunity to correct it. And if they fail to correct it and they're still subject to it, and it's so pervasive that they're unable to do their job in a meaningful way, then the law says, well, that's the same thing as if we just fire you. Giving someone an employment circumstance, an environment that is so toxic that no reasonable person would stay is the same thing as letting them go. You're going to get 28 years of experience. You're going to get a lawyer who not only has litigated these cases, tried and won these cases, but one who's actually written employee manuals and handbooks for companies on this very issue of sexual harassment and discrimination. So not only have I been on the side of representing the victims, I've actually wrote policy for companies to prevent this in the workplace. So you're going to get that wealth of information from both sides and the experience from the plaintiff's perspective, from the victim's perspective, I should say, in handling these cases. The most important thing to understand about sexual harassment is that if you feel that you're a subject of it, to contact a lawyer. Because you need assistance in navigating the reporting of that event or the problem in the workplace. A lot of people will quit their job before reporting an event, even though they've experienced the sexual harassment and discrimination in the workplace, because they didn't exhaust all of the remedies available to them that their job and their employer had to offer them, and they leave before giving their employer the opportunity to correct it, they're not able to later bring a case against their employer. There is no cost. If I get a call from someone who believes that they're subject to sexual harassment or discrimination in the workplace, and they tell me their scenario, I explain the law to them. I explain what their rights are. I also explain what their responsibilities are. So they know going forward what they need to do in order to protect themselves.